All right, welcome to the Darien Sewer Commission. As we have a couple of public hearings and a regular meeting on Tuesday, September 9th, 2025, here in room 206 at Town Hall, and we're calling the meeting to order at 4:33 p.m. So I'm gonna do the public hearings separately because they're on different topics. So first I'll call public hearing number 1, which is related to our sanitary sewer user fees. And
Public notice?
have a public notice?
Do we have notice?
Yes, it might not be in there, but
Or
Joanne
you should
sent it
read-
to
you
us
should read it.
numerous
Yeah.
times.
I
Oh, you have to
should
read it?
Yeah.
Yeah, hold on, let me find the public notice.
Oh, the notice. I mean, it mentions it here in the minutes. I don't know if that.
Yeah, let me
Get you halfway there.
There's
Looks like we
Joanne.
didn't include that in the agenda.
Oh, no worries. He should read it, though.
Yeah, I do like reading it, so I'm
Right.
looking for it.
Do you want me to go get it?
Here we go, public hearing legal notice.
Okay, you got it.
Zoomy.
Thought he had it memorized.
Okay, here is the legal notice. Notice to sewer users of public hearing on proposed amendments to sanitary sewer regulations. Oh, that's that one. Okay, it's both. Okay, so I'm gonna read them both in one here. The Town of Darien Sewer Commission will conduct a public hearing on Tuesday, September 9th, 2025, 4:30 p.m. for the purposes of affording property owners and residents with the Town of Darien an opportunity to be heard concerning proposed amendments to the Darien Code of Ordinance, Appendix C, Administrative Regulations, sewer user fees, Article 11, sanitary sewer regulations, Section 1000-6, subsection amendments in relevant part are proposed up to the following rates. 6-2.1, effective October 1, 2025, the standard charge shall be at a rate of $7.50 per 100 cubic feet of water, a 0.00% change. 6-3.1, effective October 1, 2025, the minimum service charge shall be $291.43 per annum, a 0.00% change. All members of the public are invited to participate and will be given an opportunity to be heard regarding the proposed changes. By order of the Darien Sewer Commission, Craig J. Flaherty, P.E., Chairman. And that was published on when was that published? It would have been, this email was 8/21. What was the published, Darien Times published date after that? Well, anyway.
At least 10 days
Yeah.
before today.
Okay.
Minimum of 10 days before this public hearing.
Having read item number 1 and item number 2, I will hereby take public comment on item number 1, which is the setting of our sanitary sewer user fees. Mr. Oben.
Thank you.
It's nice to see you again.
State your name, address.
If you're only coming once a year, we got to be doing something right.
Put your hand on the Bible.
Thank
Yeah.
you for having today's public hearing and being the one person who's here to represent the public. I wish to...
State your name, of course.
For the record, the name is Rolf Oben. I reside at 9 Archer Lane here in Darien. When I first heard of the proposed 0% increase, I had to take my breath because it was, kind of a seminal moment that, first of all, it's 0%, okay?
It's the first time we ever agreed.
Yeah, I noticed that in the meeting. You were like, 7, 0, 0, 0, okay. But more so, to me, it demonstrates that finally, after all the work, the dedication of both the Commission and Public Works Department of Sewers, we're starting to see some real benefits paying off. So it makes me certainly more optimistic and enthusiastic about going forward to phase 3. At the same time, I couldn't help but notice that we had the sewer breakdown near water, which certainly reminds us that the overall system is still fragile and needs constant vigilance, which I know the Commission and Department of Public Works Sewer Division will continue to monitor and react to. So I'm here to say thank you, congratulations, and carry on. I also want to stay on, so I make sure that you all vote accordingly.
We can't,
All right.
we can't go any.
Thank you, sir.
Ralph, you're still on the RTM, right?
Yeah, I'm going to hang for the second public hearing,
Yep.
because you're going to be talking about the sump
That should be
pumps.
interesting.
You probably don't even need to sit down,
Oh,
judging by the line of
okay.
people
Yeah, by
behind you.
the amount of,
But hold on.
the crowd that's all backed up there.
Thank you for your comments,
Okay.
sir. And I see no other members of the public looking to make testimony regarding our sanitary sewer user fees. Did we receive anything by email or letter?
Not that we're aware of.
Not that we're aware of. Okay, so with that, I'd entertain a motion to close the public hearing.
I'll move that.
I'll second.
Okay, Reese firsts, Peter seconds. Any further discussion? All those in favor of closing the public hearing? All right, public hearing on item number 1 is closed. And now we're going to open the second public hearing number 2 on the sump pump removal and proposed amendments to the Code of Ordinances. And I'll just refer back in the recording and the minutes to the public notice that I previously read. With that, I will take comment from the public on item number 2.
Rolf Owen, 9 Archer Lane, and I'm here to also comment on the sump pump ordinance.
Yes, sir.
Okay, and, we had the meeting together with the Public Works Committee, and I think I can speak fairly well on their behalf that there is clearly support from the committee for this initiative. I wrote an email not too long ago to Ed to remind him of the RTM schedule for the remainder of this session. And we have basically September, and that is pretty much a full agenda and a set agenda. And then we have October, and that's the end of the sessions or the meetings of the RTM for this session. So if we want to try and get something moving in the way of the ordinance with the RTM vote, October is, within this session, the last opportunity. If we were to miss that for whatever reason, that would definitely push us into, I would say, probably the early part of next year. Okay, so I just want to pass that on for your consideration. Other than that, I'm familiar with, the letter, I'm familiar with the affidavit and the requirement of photographs and all of that sort of thing. All I would say to you in that regard is do everything you can to reach out to the community, to try and allay their fears, to try and answer their questions. I would be willing to help in whatever capacity I can. I already am to some degree through the RTM. But I think it's going to be extremely important because I don't think there's a clear, per se, understanding by the public. I had already received some feedback that, well, we'll see about this, kind of thing. Okay, and I don't think they realize what they're dealing with, frankly, okay, in terms of the regulations that are involved, that you have all the right to do this. So I think that has to be brought out as diplomatically as possible, but at the same time making it clear to them that this is serious. The amount of I&I is still very significant, even though we've had a lot of progress, and that we have to continue to move forward to bring it down. I really want to get us in a position where we can go back to Stanford and say, we need to have a talk about the minimum. And so that's my thoughts and observations that I would pass on in regards to the Sump Pump initiative.
Thank you, sir.
Perfect.
All right, I see nobody else in the room looking to make public comment. Darren, did we receive any emails or letters regarding this one?
No, none that we're aware
Okay,
of.
none that we are aware of. All right, with that, I'll entertain a motion to close the public hearing.
I'll move that. Peter got it. I'll
Okay,
second.
we give Peter the first on that one, and the gunslinger, and Reese the second. Any further discussion? All those in favor? All right, public hearing number 2 is closed. So now we're going to call our regular meeting to order right on schedule at 4:45. Well done. And I'm going to take it slightly out of order because we have one of our town attorneys on the phone to help us with our discussion of the sump pump removal part policy. So we're going to go right to item number 4. Mr. Bob Burney is on the phone and talk about the proposed amendments to the Darien Code of Ordinance. And if I recall from our, good evening, good afternoon, I don't know, 4:45, we'll call that afternoon.
Good afternoon.
If I recall, part of our desire to have your counsel available to us at this meeting was to basically make sure that we need a new ordinance adopted by the RTM to set our regulations to allow us to require sewer users to complete this affidavit and also to have the ability to levy fines in certain articulated situations. So did I describe the question at hand well enough for you, Bob?
Yeah, because I totally believe that we're a semi-autonomous committee and we don't need to go to the selectmen or the RTM.
So with that, Bob, your thoughts? I guess we should do Mr. Hill and Mr. Burney
Yeah.
for the remainder of the meeting, just so.
Just for the minutes, so it's very clear.
Mr. Burney, your thoughts?
Attorney.
Thank you.
Attorney Burney,
Happy to answer the
Commissioner Hill.
happy to answer the questions here. In a nutshell, I would agree that the Sewer Commission has the authority to adopt these regulations on its own. The question becomes where does the authority derive to enforce fines for violations of these regulations? It is not so clear that the Sewer Commission on its own would have the authority to levy fines for violations of these regulations. Conversely, state law, state statute makes very clear that through ordinances, the town has the clear authority to levy fines for miscellaneous violations of both ordinances and regulations. The purpose of adopting both regulations by the Sewer Commission and an ordinance by the RTM is twofold. First, adopting the regulations allows the Sewer Commission to address the problem directly. It allows the Sewer Commission to react to how these regulations are implemented, how they may need to be addressed later on down the road, while on the other hand, adopting an ordinance allows and encompasses the authority to impose fines for residents who violate Sewer Commission's regulations relating to sump pump removals and sump pump discharges. So together they harmonize nicely. One, the regulations outline the actual structure and form of how the Sewer Commission can go about tracking down and reducing and eliminating illicit discharges, while the ordinance imposes a legal structure, a legal framework for imposing fines for residents who do not comply.
And wouldn't that legal structure that you're talking about be the staff issues the fine, the commission adjudicates the fine? Wouldn't we have then a judge and jury sort of system already set up, absent the RTM or selectmen's approval?
The issue is that unlike with some other categories of fines or assessments or charges, there's no clear explicit basis upon which the Sewer Commission can say this statute grants us the authority to fine people for this kind of activity. There's no miscellaneous catch-all provision for fines. Conversely, there is for the RTM under statute 7-148. So really, it's tying this into an ordinance, you're tying it into a valid legal basis to be able to impose a larger range of fines than what the Sewer Commission would otherwise be able to impose by itself.
Now, once this is established, can we change the fine structure without having to go back to the RTM?
No, and that is not so much an issue of going back to the RTM. That is more so an issue of what state law allows. Under statute 7-148, which is the general municipal powers statute, towns are allowed to impose, and within town I mean any agency or entity within the town is allowed to impose miscellaneous fines for various violations of regulations and ordinances of up to $250 per violation. You'll see in both the regulations and the ordinances, we have included $250 per violation. That's for a reason. It's to align with what the cap is, so to say, under the state statute for miscellaneous fines. If the state legislature revises that statute to update the cap on those fines, which they do regularly, then correspondingly, you would be able to go back and amend those fines within the regulations without amending the ordinance, because ultimately the ordinance ties back to the statute itself.
Shouldn't we
If the
then-
statute grants you a higher cap, then you could do so through the regulations.
So then,
I'm sorry, go ahead.
shouldn't our ask for the RTM right now reference the ordinance and not the fine? Up to the maximum fine under section -7-148, and give us the flexibility later if they increase that number?
I'm sorry, would I be able to ask you to just
Shouldn't we-
rephrase or repeat the question?
Shouldn't we then just reference the statute as the maximum fine going forward? Should the legislature then change that to $500, we would be then allowed to modify ours without going through this structure again. The greater of $250 or allowed by state statute. Wouldn't that make more sense?
As in reference directly the statute.
Correct.
Rather than a dollar amount, so to say.
Correct.
Or both, yeah.
Or both, greater of.
Yes, now I'm currently in a battle with Microsoft Word as I pull up my drafts documents in front of me. But my recollection is that the draft ordinance does make direct reference to that statute. At
It
the
does.
bottom of the ordinance text.
It does. I have your ordinance in front
But
of
it
me.
also says it at $250.
It says each violation shall be punishable by a civil penalty that does not exceed $250 per violation, or the maximum amount allowed by
Oh, there you go.
7-148C10.
Okay.
Okay.
So I think you wrote it perfectly, personally.
Great idea,
Thank
Reese.
you.
No, but it had to.
Good job, Bob.
Susan, in
Oh,
order-
Attorney
in order
Bernie.
To be 250, the way you could read that is
Yeah.
250 is the maximum, or it has to have a comma.
Or the max, or you want to add a comma?
It's
between-
fine, it's fine.
Yeah.
You might want to add a comma, Attorney Bernie, but,
And this-
Feeling better, I can add that in.
okay. So
Reese,
it'd
do
be
you have any
comma
more?
or comma.
So is there any way that if we wanted to expedite this and have this go forward, could we institute this as a policy, as a commission without the fine? And mandate the affidavit without the stick, and then do the stick later if this were taking too long? Or is it
I
better?
think that's a good analogy. In short, yes, you could do carrot without stick at this time.
Okay. I mean, that gives us.
So,
some
hold on a
but-
second. I just want to go in order here.
Okay.
So, Reese, do you have any
No,
other
I'm
questions?
good, thank you.
Okay. Susan, do you have
I
any
have no
questions?
questions.
Peter, do you have any
I have
questions?
one. If we issue a fine, who collects it?
Mhm.
Who gets
Who
the
collects
Who
the
gets the
fine?
money?
I mean, how is the money collected?
So the check is, well, I think it would depend on, I want to make sure I answer the right question here. If we're in a situation where a resident is not complying with the requirements of the regulations, they haven't returned a compliance statement in a timely fashion or not at all. The superintendent of sewer services levies the fine. The fine would go out to the resident. The resident would, in most cases, especially when you compare them to how fines work under other ordinances. Let's say they comply, they issue a check, they would write it back. In this case, I think that would probably go to, good question.
Well, I think Ed, you may have had a conversation with the tax collector on this, who runs our sewer user fees each year. And it would be basically through the same system as our sewer user fees, correct?
That's correct. Want to implement it as part of the sewer user fee invoice and have both of the charges on there. If the fine is going to be applied to that resident, if not, it won't be on that invoice at all.
And Darren,
It's
is
going to be
you
discussed later on number 7.
Oh, we are going to discuss that mechanism under item
Ed's
number
going to talk
7.
about the CompuTill bill
Okay.
and how the tax collector is going to help us under number 7.
Does that answer your question, Peter?
Yes.
Okay. Bob, do you have questions?
Yeah,
No.
Oh, I'm sorry. Commissioner Hill, do you have questions?
I do. So if we were to go this route, can the frequency of the fine be changed? Or could it be a daily fine, a weekly fine, a monthly fine, a quarterly fine, a biannual fine, a yearly fine?
The short answer is yes. I think one of the core benefits to having both the regulations and the ordinance is that the ordinance authorizes and enforces the fine, while the regulations give you the flexibility to address those sort of questions as you move along. If you believe it is reasonable and necessary to impose fines on a more frequent basis, you can do so under the regulations and still be enforceable under the ordinance. I think there is an element of how reasonable the frequency of them are and how defensible that might be if they were challenged. But in a general sense, yes, you could revise how often or how scattered those fines are imposed under the regulations according to what the Sewer Commission wants to do.
Oh, that's great.
Okay, and I hate to open another can of worms here, but
Do you?
I have chapter 103 in front of me, from the state statutes, thinking that covered this. And as of right now, we have fog ordinances which impose fines. And I don't see anywhere on this where those are backed up by chapter 103. So do we need to take those to this step too?
Can I see 103?
Sure.
Yeah. To make sure I understand the question, are you asking where under Chapter 103 we are deriving the ability to impose these fines?
No, I don't see it in there, so I also don't see the ability to impose our fog fines. So I'm wondering if we need to take this also as the fog as code of ordinance now.
Mm-hmm.
This blows me away that we have to do this, but I'm not a political animal.
Mm-hmm. Offhand, as I recall, the fog regulations are under Appendix C of the Code of Ordinances as regulations from the Sewer Commission, as opposed to an ordinance duly adopted by the RTM. In a very general sense, Chapter 103 and the Code of Ordinances grant the Sewer Commission the authority to generally regulate and oversee regulations for the sewer system. That is the police power, so to say, here. The ability to levy fines, and this is why we're tying this into an ordinance, that is not as clear under 103. There is an open question, I would say. If the Sewer Commission were solely relying under 103 to impose fines, there is a bit of an open question as to where that derives from. That is why under the ordinance we're tying it over to Statute 7-148, which allows the levying of fines for miscellaneous violations of ordinances and regulations.
So the answer is maybe it's an issue. But this brings up another conversation and kind of where this started, and I remember it as a part of the fog conversation as well, which is if there is a use of the sewers by particular users, or that we have the ability to levy user fees based on how the sewer is used, right? Right now you put more in, we charge you more. But in the case of fogs, if you are not maintaining your fog, you are discharging to the sewers grease and oil. And that grease and oil is much more expensive for us to transmit and convey and treat. And therefore there is in my mind, a connection between an increased fee,
Surcharge.
an increased sewer charge.
Surcharge.
Oh, a surcharge.
No.
So is it, yeah, so I don't remember the fog ordinance, and I don't have it in front of me, whether it is labeled a fine or a surcharge or, an enhanced fee or
I
that
think
sort
it's
of
a
thing.
fine.
It's listed as a fine.
I think so.
Yeah, okay. So I guess, Attorney Bernie, back to you. With that logic of our ability to set user fees, in the case of non-compliant FOG users, would we have the ability to levy a surcharge because there is a relationship to their discharge and the cost of our maintenance?
I believe the rationale of what you just said is sound. It is reasonable. The issue is that there is no explicit statutory text I could point to saying, yes, you have the authority to do that. It's an implied power. With FOG, there's a bit of a safety in numbers concept, so to say, because throughout the state they have been around longer. They have been challenged and tested, so there's more of a basis to point to them and say, we know it can withstand legal challenge. With something like the Sump Pump regulations here, it's a little different. We don't have that same long, existing precedent, so to say. Would it be possible to do something directly analogous here, the surcharge concept, to the Sump Pump regulations vis-a-vis what is done under FOG? Yes, but it's an implied power. I think my recommendation is that by doing it as both a set of regulations and under an ordinance, you are significantly increasing the legal basis upon which to impose fines for violations, and you're far more likely to withstand a challenge or a contestation of those fines.
I was applying that logic because it was a little easier to do in the case of a FOG, because we have a few dozen FOG users. We know very clearly that a discharge with fats, oils, and greases is more expensive to deal with. Where we kind of ran into a dead end using that logic on the sump pumps was that someone could have a connected sump pump and it only turns on 2 days a year. Someone could have a connected sump pump and it's firing every day. So we have no real way to understand how to charge somebody for the extra use because we don't know what that extra use is.
Exactly, yes. There's a difference in function between these two regulations in many ways, and I think that ordinance sort of covers and addresses the ability to enforce the different goals that are meant to be accomplished here.
Commissioner Hill, any further questions?
No.
Okay, going back around to the commissioners, any further questions for Attorney Bernie? All right.
Yeah, I have one.
Yes, sir.
If a group of people got together who were against this ordinance about removing the sump pump, the ordinance would give us further protection in court, would it?
Correct.
Okay,
Yes, it would.
thank you.
Just one quick question. What would the challenge in court be? Is that we're doing it for FOG, and then that sort of feels more right? But to me, it's a very similar argument. Does that mean that our FOG ordinance is also slightly suspect? Or if we did this because it's more likely there's more people, there's more likely we'd be challenged in court? I'm just not seeing a huge difference between FOG and this. Now, I know, Craig, it's a maintenance issue and grease does clog the system, but there may be some pumps, like from what we've seen in statistical data, some pumps are a huge problem for I&I, which is a social cost, burdening the system, potential fines from DEEP, et cetera. So the public part of it is still there. They're both very similar in that. So really all we're doing is like defending against a lawsuit that hasn't happened yet.
The way I've understood the conversation is if we call it a fine, it's suspect.
So let's
And it's better backed up by an ordinance. So we have a choice in the case of FOGs. We either also get an ordinance for that to fine, or we call it, a surcharge for FOG intense waste being discharged.
Well, we haven't done that.
I have another.
But we haven't done that. So these are things that we should do.
I have another question.
Yes, sir.
Attorney, if a group of people got together who had sump pumps and they were discharging into the sewer system, And they made the argument, well, we have nowhere else to put this. Is there a likelihood that the law would require us to accommodate that?
In a general sense, no. Simply because you have a need does not mean you're allowed to use public utilities and resources, willy-nilly, without measure or without restriction.
So in that case, they'd be on their own
Well, they could pay for it.
to solve the problem. Well, that's the next question. I mean, for those who have no place to put it, could they demand that they pay for it?
I'll be honest, I don't necessarily know if this is a legal question, so to say. It is what they can and can't do under the law. That I can address within ordinances and regulations. What somebody does in a predicament where they have, sump pump discharge that cannot be connected, what do they do with that water and where do they run it? I couldn't say. That's beyond my skill set.
But I mean, if they stayed connected, could they make an argument? I guess they could, of course, that they should be allowed to pay extra for it?
I guess
That'd be up to us?
Yeah, in that case, I guess, would it be the sewer commission that makes the judgment, you have to disconnect, or you can stay connected, and here are the terms of your connection?
Right.
I think that is an excellent question, because it actually gets into a key point of the regulations here. We have left in language within the regulations I believe the defined term is an authorized discharge, that in effect says discharges into the sewer system that are allowed, sump pump discharges that are allowed. That is not something that is necessarily expanded on elsewhere within regulations, but the point of that reference, that definition in there, is it would allow you, the commission, to address that down the road. Should somebody come and say to you that I want to pay more money to discharge, and you as the commission determine that that is reasonable and acceptable, you would now be allowed to deem that an authorized discharge.
Okay, so that's permitted in our regs for us to make that judgment.
Yeah,
It's in the new regulation.
Okay.
that's bothered me for a long time.
Correct.
Yeah.
One quick follow-up on that. I'm just looking to compare the fog ordinance to the sump pump ordinance. It's illegal. It's illegal under the plumbing code to hook a sump pump to the sanitary sewer. So there's already a violation of a code going on by a homeowner that's hooked up. There's no violation of code for a fog poorly maintained grease trap per se under the code. So isn't a sump pump hookup more illegal and a harder argument for a homeowner to make that they're being aggrieved by a fine than the fog ordinance would be for a restaurant?
Well, I would say
I would agree with that.
well,
Yes.
the fog has a permit from the state, and they would be in violation of the terms of their state permit.
And hooking up a sump pump to the sanitary sewer is a violation of the plumbing code.
Yeah.
Let me ask this. I mean, if a person were about to be fined, and he brought up the argument, well, look, there's just no place for me to put it, I will pay extra in lieu of the fine?
We could think about that.
I mean, that would be a decision for us, right?
Right, separate issue.
Okay.
So in that sense, wouldn't we be even more on solid ground, not having this go to the RTM, not having this go to Board of Selectmen than we are with the fog ordinance, given that they're already violating the plumbing code by putting a sump pump into the sanitary sewer?
I think that the two key differences, so to say. The first is it is already unauthorized under the Code of Ordinances to discharge sump pumps into the sewer system. As I understand it, the key issue is that simply saying residents cannot do something in this circumstance clearly isn't enough, because they're still doing it anyway. The purpose of this regulation, again, as I have understood it and as I've drafted it accordingly, is to really for the sewer commission to go about issuing these compliance statements, collecting them, and being able to winnow down where the discharges are coming from, so to say. imposing a fine simply for doing something that is not allowed is one thing. Imposing a fine for not complying with a regulatory scheme that requires residents to return compliance statements, that's a separate concept.
Perfect.
So
You
the reason we are bulking
yeah.
up the legal authority to levy these fines is because the compliance statement concept is unique. It's not a direct correlation or directly analogous to FOG. It does require, in my opinion, a bit more of a justification and a legal structure to be enforceable.
You absolutely answered my question. Thank you.
Great.
So,
Susan,
oh, sorry.
Who's going to go around?
I'm good.
Susan's good. Reese?
I'm good.
Thank you. Peter? Mr. Hill?
So going with that legal structure, is there, and I'm sorry, I read it, but I don't recall it, a part of the regs that are going to speak to if they give a false and untrue, or if they switch back, because it's only PVC piping. I mean, if someone's in the situation that Peter described, I have nowhere else to put it, it's not beyond the realm of possibility that they'll switch it and switch it back. And, you know, a $200 fine, they would laugh at. I mean, compared in the big scope of things.
Well, I think, as we've talked about it, we have the ability
Per day.
to change our regulations, to change the frequency and for which actions that we would have the authority to fine for. And I think, again, our hope is, let's get in the water. Let's start swimming.
I understand that.
Let's
but now
see
we have
what
to
let's
go
see what
through
happens.
A large process to get, you know, every
But
time.
what I heard is he said that we could go to daily without going back to RTM just by revising our regulations.
Aren't we required, or aren't we requiring now to have them fill out that form every year?
I don't know if it was annually. No, that would be somewhat onerous.
No, it was one and done.
Okay. I appreciate
Yes.
that there are going to be long tails on this bell curve. And there will be people meeting every example that you're giving.
Yep.
But I am focused on that middle of the bell curve and trying to get compliance there. And we can evaluate annually whether or not we need to turn up the heat and modify our regs and do something different. And I think in this first round, we're going to learn a lot, and that will inform what we do in the future.
Yep, good thought.
Yeah, I just don't like the idea of it going from a common sense law to a political potato.
Well, we could change it then. If this becomes onerous, we just take that $250 fine for not signing the affidavit, and we move forward and figure it out from there. And when we catch people, we catch people. Or we do the affidavit.
I mean,
Well, what I would say is for this to be successful, to Rolf's point, we need to be able to sell it and educate our users on the importance of it and the importance of its compliance. And I think thinking of the Board of Selectmen or the representative town meeting as our friends and allies in that educational effort is how I would approach it. And I think having this, basically approved by those bodies gives us, just on a very one-on-one sense, it's not just us,
It's PR.
it's the entire town, including an elected body, not an appointed body. So I just think it gives us, aside from the legal leg to stand on, I think it gives us a better practical and political leg to stand on.
And it gives us the opportunity to go out and talk to these people.
Yeah.
Yes.
Because you're going to be doing this before the RTM, so
Well,
it will
yes.
be public, very public.
But as I read the letter going out, I mean, there's no indication that there's anything but get rid of it.
There is,
That's
oh, the
right.
letter?
But Peter, it's illegal. They have to send that letter that way.
Pardon me?
It's illegal to put sump pump into a
Well,
sewer.
that
You
may
can't,
be.
you can't publish it.
That may be, but still, people are,
We're asking for your help.
are gonna say, well,
Yeah.
help.
Yes, they are.
I mean,
Well, then they can come in.
because it gets to be.
Yeah, to your point, Peter, maybe there needs to be a,
Well, I don't wanna make it too easy.
to contest, yeah, exactly, to contest this requirement, blah, 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 or
I
something
mean,
like
is
that.
there a chance for them to tie into the
Sanitary.
stormwater system?
Yeah, well, depending if it's available and if it's, blah, blah,
Exactly.
yeah.
So there may be options for these people. They may be
Yeah,
expensive.
but I mean, what I'm saying is they may need help.
Again,
Right.
at the, well, yeah,
I
and
mean, figuring that out.
I'm not gonna reread this again now.
They'll need to hire an engineer.
I'm not going to reread this again now. Ed and I have talked about this. Ed and his staff are available to anybody that gets this and needs help. And it says right in the letter, you can reach out to us via email. Here's the email address
Okay.
with any
All right.
question.
And they're the same.
But to your point, as we have identified, we have the authority to deal with very complicated edge cases and adjudicate. How much we need to say that in this first letter or make sure that's understood, I guess is a question.
Well, I mean, I just feel that if you do that, people are gonna do a lot less dodging.
Look, I'm sorry, it's in here, I read it. The
Yeah.
sewer department staff and sewer commission are available for consultation if needed to provide guidance for special
Right.
situations.
Right.
So it's in there,
Good.
yeah.
We want to work with people.
Yeah, we want
Best
compliance.
of our ability, we want them to
We
become
want
compliant, and we want to work with them.
We want cooperation, we have no desire to be
Yeah.
No, I mean,
punitive.
that goes toward.
I wanna say that very
trying to
clearly.
sell
We want cooperation, we have no desire to be punitive. Commissioners, any further questions for Attorney Burney? Mr. Gentile, Mr. Ostfine, any further comments, statements, questions?
No.
No, I think you guys had a good conversation about this. And just to give you a quick update on the RTM schedule, we're looking to get through the RTM and Board of Selectmen process in October. So, which is why we put the public hearing in September as, not to say last minute, but due to Rolf's email. And I want to thank him. Kind of gave me a better perspective on what the timing was here. And so I think we have time to get it through October.
Great.
Thank you, sir.
Wonderful.
Attorney Burney, thank you very much for your participation today. Hold on. I just want to say you have proven once again why it is important to seek counsel from experts. So thank you very much.
Thank you. I appreciate that. Happy to be here.
Now you want me to hang up?
Yeah, bye-bye.
Bye-bye.
See ya.
All right, bye-bye.
He was great.
Yeah.
Okay, so
Next on the agenda or going back?
yeah, let's just go backwards and we'll run all through everything in order. So let's go to item number 2, approval of our regular meeting minutes of August 12th.
Minus 16.
Any comments or edits on the August 12th minutes?
I think I would make a motion to approve.
Okay. Peter moves to approve.
One second.
Reese seconds. Any further discussion? All those in favor? Opposed? Abstain? Okay, so that's 4 in favor, Susan abstaining. As
I
she
missed
was
the meeting.
Absent. Item number 3, approval of our special meeting minutes from August 27th. By the way, I want to point out that Channel 79 is using AI to summarize discussions,
Wow.
and then they go back and, provide some human editing on top of that. But they are succinct and accurate. They send them to me after the meeting to make sure I agree with them.
How do they get our humor in all this?
There's not much humor in the minutes. Or, maybe there was lively discussion.
Okay.
All right, so back on our 27th. Do I have a motion?
It's gotta be you guys, because Susan and I weren't there.
I wasn't there, yeah, I'm
So we're
sorry. August,
recused.
I was out.
We're
Peter or
abstaining.
Bob, you have a motion on the special meeting minutes of August 27th, page 3.
Oh, yeah.
Come on, you guys gotta do some lifting over there. Come on, Bob.
Well, I approve holding. I move to approve the holding of
Gotta
the
be-
fees. So I'll move to approve these.
Come on, Bob, you gotta second it.
I'll second.
Craig can't do it.
Do you try to avoid these things? No, there's, you second.
Today, yeah, I'm in no mood at the moment.
Okay, okay. All those in favor?
All that stuff.
3 in favor. Any against? Any abstentions?
We're abstaining.
So Reese and Susan will abstain.
Even though I raised my hand.
Okay,
Instinctively.
so now let's have some fun. Discussion and action of the proposed amendments to the Darien Code of Ordinance. I think the motion might be to approve the drafting of the ordinance and for forwarding it on for approval to the Board of Selectmen and RTM.
I'll make that motion.
I'll second it.
Okay, we have a first and a second on the motion. Any further discussion on the motion? And I'll take a vote. All those in favor of the motion, raise your hand. All those opposed to the motion, raise your hand. All right, 4-1. It passes, and I think we understand your position, which is we are autonomous and should act accordingly.
Yes, and with this, we're handing over our power to others and making it political as opposed to just for the good of the town.
And my hope is that we are strengthening our ability to act, not weakening it.
Yeah, I agree.
We'll see.
We
Yeah.
will see.
We can always,
I agree. Item number 5 is setting of the user fee, discussion and action. I think the motion would be to,
May I?
you want to approve that one?
No, I would like to say something,
Oh, please.
because I was the one who called for the meeting. For the
Oh, that's
public
correct.
meeting.
Correct.
We didn't need to do it because
Yeah.
there is no change in the rate.
Yes, sir.
But I feel as though we should take these 30 seconds to thank staff and the field staff for their diligent work and the ability to keep a quality system out there and do so with a reasonable rate. And I applaud them for that. I do not take any credit for it. As a member of the committee, of the commission, I believe it is all on them. And as a member of the commission and as a homeowner in Darien, I would wholeheartedly like to thank them.
That's great.
Here, here.
Now, I would make a motion to accept the 0% increase for this, the year 2020, the sewer rate 2025, 2026.
Do I get a second?
Second.
We'll all second. Everybody
We can all
seconds.
second. We can all second. So-
We all second that.
Sure.
A 0%
We'll give it to Susan, just to
increase?
make it easy on the
I think
minutes.
she was a little quicker this time on the budget.
Any further discussion on the motion? All those in favor? All right, that's a unanimous one.
Thank you for being here.
Yes, thank you, Rob.
I want two more, just so you know. That's what I'm gunning for.
Yeah, we'll put you down for next year.
I want to be in the discussion that you want to be in.
All right, item number 6.
Table of appeals.
Oh, yes, this is what we do each year after we get through sewer user fee appeal season.
Oh, we have a up,
We
down.
have the chart.
Yeah.
Penny chart.
But it's not the penny
But
chart
now
anymore.
The spirit of pennies. She's still with us.
The spirit of penny. We have the summary. So let's see. Few leaks.
Yeah.
Irrigation systems.
Oh, number 16, the one or 15, 16, it was a leak, it wasn't a mathematical error.
Yeah, toilet running.
No, it
Oh,
was the
16.
plumbing blew up.
That was also a leak.
Oh, yeah,
Okay.
huge leak. With pictures, remember?
Leak, fire, leak, frozen pipes, toilet running, toilet overflowing. Well, that's pretty good. We only had 3 chalked up to irrigation, which I think is great.
That is great, that 5-month one.
And, there were a couple of, we gave you information about reduced usage, probably like a house turnover or something.
Yeah.
But the lion's share is leaks or running toilets or things
I
like
don't
that.
think we had as many as other years. What was it?
26 is,
No, we
feel
had
like that's
some years
similar.
we seemed to have like many more, didn't we?
What, appeals?
Yeah.
Yeah, we've been in the 40s.
Darren, is that your sort of recollection that it was more other years?
Over last year?
Yeah.
I don't know.
I remember some, I don't know, I never had a count pop, but it seemed like other years we had more.
Yeah, I would have thought there was a couple years where we had 2 full months, and I think they capped it like 20 or so a month.
Yeah.
well, thank you, Joanne, for that summary.
Yes,
Any
thank
other,
you.
Comments on that? And then the total amount, what did our reduce, so we reduced revenue by 35,000 through our granting of appeals.
Oh, we had that one basement flood, remember that? That one was 7,500.
Yeah.
4 people.
All right, moving on to the agenda. We're going to talk about the cover letter for the sump pump removal policy. I'm sorry, this is okay, let me say it differently. So this is now our sump pump removal policy discussion and action, and under that, we have kind of 2 updates, one on the cover letter, one on the invoice. So do we want to first approve our policy? Is that the action, Darren and Ed, you were looking for us to take on this agenda item? Or do you want to wait
And
until?
Ed's on the phone, he wanted to bring this to your attention.
Yeah.
And he wanted you to see the letter. You can see what he wrote in yellow, what's highlighted is specifically the softening of the language that you requested. And then, of course, down further, bolded and underlined is the number, $250.
I think just the word possible in the 4th line might want to be possibly.
Yes.
I mean, the whole intent of this is just to get people to come in and talk to us.
And they got it down to 1 page.
Yeah, great.
I like
It's
one
an
page.
8-point font.
Where's Craig's signature gonna go?
He's gonna switch it in right at the bottom.
Okay, my name's at the top of the page. It's right on
We'll
top.
just add your mobile right after.
Yeah.
Mine's up there too.
Yep.
Same phone number since 1956.
So I guess my question is, do we need any specific action by the commission on this item?
Should we just adopt this as
I
a
don't
letter?
think so, but
Yeah,
if you
I don't-
felt like it, you could. I could tell you that, A, you have the letter in front of you. You've already approved the proposed document, the instrument that's going
Okay,
to
we did
cause.
approve that, yeah, okay.
So you've already done that. This letter, Ed has made some edits as directed by the commission, and, he's presenting it to you to tell us if, you already came up with one typo.
Yeah.
You like it? Is it good? You want something different? I don't think you need to make a motion. When you get to B,
And we got a couple of months to
yeah.
tweak it if
and
we need to.
When you get to B, I can tell you that Ed is still working with
Gotcha.
the commission, with Computil to modify our bill. Our bill is pretty complicated. There's a lot of information on there. Ed will probably come back before the next or at the next meeting and show you a sample of what the bill is going to look like, and we probably won't need a motion then either, just to keep you guys up to speed on what we're doing.
Ed, do you have anything to add to that?
Yeah, I'm just, and Darren's spot on with that, with everything, except that I, for this letter, I would like you just to approve it, vote on it. This way it's ready to go. I have your final say. Doesn't mean you can't change it. It will be going out in January. So just so you know, but this, like we did with the ordinance, like we did with the affidavit, you guys sign off on the final product. This is it right here, minus the one change that I will make in possible to possibly, or, I never said I was an English major. But yeah, just to, let's codify this, close it. Always the door you can reopen if you'd like, but this now means that all our documents are ready to go to the Board of Selectmen and then to the RTM.
Does the commissioner need more time to make a motion on this, or are you ready to do
I
it?
would make a motion to accept this letter.
Okay, Peter first,
Second.
Reese seconds. Any discussion on the attention sewer user letter?
Just one quick comment. For expediency, I would say we should approve it, but we should also send it out to test subjects so that if it needs to be
we talked
tweaked
about that.
between now and January, that we get feedback and address it accordingly.
Okay,
Interesting.
I like that. So we have a first and we have a second. We've had some discussion. Any further discussion? Okay, all those in favor, raise your hand. Okay,
Fine.
the letter is approved with the recommendation that you share it with your friends and family and see if they understand what it says. Get someone outside of the bubble.
Craig, my recollection, there was a Mrs. Flaherty.
Yes,
offered that pointed to the area.
there's several. There's
That was
yeah.
recommended. So, yeah, no, absolutely.
All right. Thank you, sir. Okay, where are we?
8.
We're on the superintendent's report.
Ed, you want to do
Ed,
this?
do
or
you want to
me
do any of it, or do you want Darren to do it?
I think Darren can handle this. I'm just going to hear and listen.
Yeah, I can repeat everything that Ed told me. Okay, so, item A, sewer rehab update. All the work is finished. The final pay request is coming. There's $120,000 worth of warranty bid item work, which is inspections of the work that they did, which is outstanding. Phase 3 rehab update. The notice of award went out yesterday. The pre-construction meeting will be scheduled mid to the end of September. Item C, Phase 2
When do we
INI.
expect mobilization? How quickly do these guys usually turn around once authorized to proceed?
The contractor?
Yeah.
I don't know about the specific case. It's usually 30 days.
Okay.
Usually, when a notice of award goes out, they usually have, 10 to 30 days so that they can get their bonds and insurance together, get the agreement signed.
What I'm recalling from last year is that we actually got a fair amount of lining done over the winter, which was then in place ahead of the spring flow season. And I guess that's what I'm hoping for this time.
So Craig, the indication I got from Lindsay and National Water Main was that they have availability sooner rather than later, so that as soon as we get them started and pointed in the right direction, they're going to start going.
Excellent.
Okay, item C, Phase 2 I&I Engineering. Ed is waiting for the Arcadis proposal. He has been forcing them to focus on the Phase 3 as our priority. So by the next meeting, we should have Arcadis' proposal for Phase 2 I&I.
Excellent.
Item C. Corbin Drive development. I know you folks drive around and see a lot of what's going on. You probably noticed some plates over at Leroy.
Yep.
Okay. So the Corbin project is in the process of crossing the post road right now. That's what's going on there. There's all kinds of utilities, electrical, sewer, gas, whatever's in their way, they're working through. That's why the plates are there. They did get their state permit, which is another issue. We could discuss some other time, but that's what's going on with Corbin Drive sewer. They're going to make the connection into the manhole at Leroy Avenue on the post road, which is pretty huge. So then I'd like to add item E and mention that the flood proofing at Nearwater and Stony Brook is scheduled to be finished mechanic-wise this Friday. We expect to get the parts that we've been waiting for, which apparently are coming from China. You've seen the block work around the transformer and things like that. And what we were waiting for was the metal and rubber pieces that go in between. And that'll be Friday. Hopefully we'll start the installation process there. And also the aesthetics of the block work. We're looking into that. We're trying to come up with a finish that is in keeping with the pump station. We don't know what it's going to look like yet. It might be stucco. It might be a fake brick or something, but something to, so it's just not bare block, right? That's going to happen. And that's it for the superintendent's report. If there's any questions.
Any commissioner questions for the superintendent?
No, I just have a quick comment answering one of the questions you had last month. You asked Ed about the Connecticut Clean Water Fund. It's 80%. It's 80% federal with a 20% Connecticut match.
So Craig, I think Darren has a little bit on that too. I think he spoke to Lindsay about it.
On the clean water reimbursement, like we got whatever it was, 45 cents or 55 cents on the dollar back for the I&I study last time. Do we anticipate that same reimbursement given the reduction in federal funding all around?
Our engineers said they believed that the funding would not be at risk.
Okay.
I forget the split, but they felt that it was not in jeopardy for whatever reason, the political climate or whatever, which was, I think,
They would know more than us, so
yeah, that
knock
was,
on wood and hope that's true.
Darren, one quick question on the Corbin development. The sewer beforehand went towards the post road and then around. They changed the flow completely when they built that project, didn't they? And this is the tap in for that second part, the newer chunk where Bank of America and all the low-rise buildings were.
yes,
It
you are
used to
correct.
go into the other system.
In front of the strip mall from, I'll call it the exit ramp, in front of the old brown bank,
Yeah.
everything went towards Corbin Drive and crossed the road and then went down to Leroy. And what we found is the pipe gets larger at Leroy and the post road.
It's an 18
Yeah.
instead of a 15, right?
Yeah.
24.
Yeah, something like that.
So we bypassed an area of concern, because I know
12 to-
that there were problems that
Yeah.
came down the other way from Grove Street, et cetera.
The pipe in front of the theater is fuller than the pipe
Right.
at Leroy
Yes.
Avenue. So,
There's more capacity once you get to Leroy, so that's why they're making that diagonal cut. So the sewer that used to go across the strip mall down to Corbin now goes towards the exit ramp and then crosses the post road to get directly,
Where there's a much bigger pipe.
To the bigger pipe, where
Benefits
there's more
everything
capacity.
after development.
yes.
Right. It wasn't just because of the development, it actually helped even, if you'd left everything alone, it would be worse than today.
they're reducing the peak rate of runoff to that one pipe.
Right. Exactly. That's where I'm going.
Yeah, that's why they did it. They needed more capacity.
And we had an inflow problem
Right there.
right there
Yeah.
too, that has been removed.
Yep.
Any further comments or questions for the superintendents? Any new business? Peter,
Make a motion to be adjourned.
all those in favor?
We need a second.
I'll second. It's a universal second, universal approval.
If everybody just gets up and walks out, do we need a second?
I don't know, we might have to have a special meeting to close the meeting.
Thank you, Channel 79, we're done.